We now move on to our technical session, which is the Oxford Debate 1. Building directly upon the structural realities of the infrastructure sector, we now move into one of the most exciting and dynamic formats of our forum, which is the Oxford-style debate. The motion before the House today is, without statutory adjudication and specialist courts, India cannot resolve construction disputes efficiently, a premise driven by a growing non-preference to arbitration by the state government. So moderating this high-stakes intellectual battle is a true titan of the Indian legal fraternity, Professor Ratan Singh, a distinguished New Delhi-based senior advocate and leading international arbitrator with 3 decades of experience at the Indian bar. Sir's practice spans across complex construction, infrastructure, and engineering disputes globally. Sir possesses extensive experience under major rules like ICC, SEAC, and LCA, regularly appearing before the Supreme Court of India, and serves prominently as the chairman of the Society of Construction Law India. We welcome you, sir. To argue passionately for the motion, please welcome our first debater, Advocate Ronak Desai, who serves as the co-chair of Society of Construction Law Mumbai, where he provides strategic leadership in promoting discourse and development in construction law and arbitration. Sir is also the head of International Construction Law Offices in Mumbai, with a distinguished practice in construction arbitration and infrastructure disputes. Partnering with him in support of the motion is Mr. Ashwani Malhotra, Managing Associate in the Dispute Resolution Team at Chandiok and Mahajan. Sir focuses mainly on commercial disputes, arbitration, and construction law, with extensive experience representing clients in complex infrastructure and commercial matters before the arbitral tribunals and court. We welcome you, sir. Standing ready to argue against the motion is Dr. Pradeep Reddy, a seasoned advocate and dispute resolution professional with a unique blend of expertise in engineering, law, and alternative dispute resolution. With qualifications in civil engineering, law, a master's degree from United States, and a PhD, Sir brings a multidisciplinary perspective to construction, corporate, and regulatory disputes as an advocate, arbitrator, and mediator. We welcome you, sir.
Vote for me.
Debating alongside Sir against the motion is Advocate Mehak Oberoi, a leading strategist with over 19 years of experience in the APEC renewable energy and infrastructure sectors. Specializing in construction law and international arbitration, ma'am has been widely recognized with the Indian National Bar Association's phenomenal SHE Award, holds a spot in the Lawwiser General Counsel's Hall of Fame, serves as a board member for the Society of Construction Law India, and is the founder of the Construct Her Global Network. We welcome you, ma'am. Professor Ratan Singh, sir, I hand over the floor to you.
Thank you. This debate, Oxford-style debate, is very tricky, I would say, because the way topic has been chosen by Professor Venkat, it was troubling me in understanding the motion itself. Motion is, this House believes that without a statutory adjudication and a specialist courts, India cannot resolve construction disputes efficiently, given the non-preference to arbitration by state governments. So this motion talks about 2 things: a statutory adjudication and a specialist courts. When we talk about statutory adjudication, what is that we are talking about? And what is that we both sides are going to fight about is, statutory adjudication is legislation brought by any particular jurisdiction or a country for quote unquote adjudication, which is an interim, which gives interim finality to a decision with respect to a dispute between contractor and employer, or main contractor or subcontractor. So, to make it simple, there are many countries in the world, they call it construction act, construction laws. They give different name in different jurisdictions, or we also generically call it security of payment legislations. So what happens is that in those jurisdictions, any dispute arising between the parties, employer, the contractor, the main contractor or the subcontractor, are to be sent to, or parties can go to adjudicators. So either you agree on an adjudicator's name, or you go to adjudicator appointing authority, they appoint adjudicators. Those adjudicators are specialists. Only then they are put on the panel, kept on the panel. So they have got that ability to understand the disputes quickly. So generally within 28 days they will decide the dispute. Until that time this decision is set aside by appellate court, because in adjudication on certain grounds you can go to courts. So there again in those jurisdictions you have got a specialist courts, that is the second topic. So against those awards, interim awards of the adjudicators, one of the parties can go to the courts, which are again specialist courts, on limited grounds that I was not heard, so violation of principle of natural justice, quote unquote, due process, or it did not have jurisdiction and so forth, not on merit. So whole process gets sorted out, adjudicated by a specialist for interim period in such a manner that it does not affect the continuity of the project. I talked about this in the morning also. So motion is, can we do without a specialist courts and the adjudication legislations which many countries have? Now we have two teams. One says we are fine without it, another says no, sorry. So let us see how it goes. So Professor Venkat has devised a process through which he'll take the blood test. So before we start the debate, he'll ask you what is your views. Everybody will be given some voting tips. Very good.
So this is what it is going to be. You are going to be deciding who is going to be the winner. So this is before the poll. So the motion is here. Without statutory adjudication and specialist courts, India cannot resolve construction disputes efficiently. So you have 5 options: strongly agree, agree, undecided, disagree, strongly disagree. So we will take a snapshot of this. After the round 1, we will ask you, did it make any change to your initial voting? Then finally we will ask you, what do you feel now? Please don't cheat, only 1 vote per person. And don't try to match it, right? So, only 47 people in the room, there are more people in the room. Everybody should vote. The number will come there, 50. I think it should be more than that. We'll take 2 minutes. I hope the data works well in the room. Yeah, it's rising, sir. 2 minutes. I think the job is made easier for Pradeep because with the strong contenders for the motion, a small twist will be enough for you. No, now. Oh, we are crossing 100. That's great. 100 people in the room. It's really done. You can also see here. Huh? I think 113. Sridhar, can you take a snapshot of this? Like we can put that. Okay, maybe after that 113. I think we know the trend now, right? So 2 people could not decide. That's good. Just 2 people could not decide. That is the magic of AI and technology today, sir. It understands how many mobile phones in the room. No, no. I think it's not possible because it's been made that from one phone you can put only one vote. If you have 2 phones, we can't help it. Okay, I think it's fine. Sridhar, you can lock the score, probably. So let the debate begin. After the first round, I'll come. So we have very short time, so we need to take care of that.
So, since blood sugar test in fasting has been done, now we need to feed all of you with the thoughts which both sides have. I have got very eminent panel of speakers from both sides. Match is always good if you have good teams playing. So first I'll ask Ronak from his team to give his thoughts as to what he believes about the motion.
Thank you, Ratan sir. Now the motion, the first survey that is out, the result of the poll that is out. So the House believes that we require specialized construction courts and statutory adjudication as well. I'll give you background of why do we require specialized courts and statutory adjudication. So today we are in arbitration, we are facing problems of courts interference after the party has obtained award in its favor. So enforcement of the award becomes a challenge for the party. There was a Privy Council judgment which said that a plight of Indian litigant starts once he has decree in his favor. Same stands true for arbitral award holder as well. His plight starts once he has arbitral award in his favor, because enforcement of the same is a big issue. And parties today are to council are asking these questions, whether even if we have good chances of getting award in our favor, it should not happen that once the award is there, it will only be a paper award. So in that particular backdrop, and from the perspective that India is on the path of building its infrastructure, You go everywhere, the infrastructure boom is there. And construction being a dominant contributor to India's GDP, there are going to be lots of construction disputes that are going to come in future. And to resolve those disputes, do we require a better dispute resolution mechanism than what we have today, that is arbitration? Or we require specialized courts and statutory adjudication? So first I'll give you the perspective, the international perspective, how things stand today world over, the jurisdictions where there are already statutory adjudication and specialized courts. So starting with UK, like Ratan sir mentioned, the Housing Grant Act of 1996, I think, so which brought in the statutory adjudication. Now, after that particular promulgation, the arbitration became a dying subject in UK because most of the construction disputes were getting resolved by means of statutory adjudication. After that, in UK, there is a Technology Construction Court. Now, Technology Construction Court is 150-year-old court. How did it start? And Ratan sir, I think in Manipal event 2 years ago mentioned that Evidence Act was to assist the jury members in the trial. Now we don't require Indian Evidence Act in Arbitration Conciliation Act. So Technology Construction Court's history was that High Court judges, when they were facing the issue of highly technical and complex dispute involving lots of technicalities like construction and infrastructure, they did not have domain knowledge. So therefore they started referring it to a person called referee. And that particular referee used to give its decision or opinion on that particular dispute or issue that was referred to him. So happened that judges started relying so heavily on the referee that referee itself became Technology and Construction Court. Now it is a division of High Court. Today, if you look at the judges, the roster of that particular Technology and Construction Court, all judges there have domain expertise and experience of having handled construction and infrastructure disputes for 35 years, 40 years. Currently, there are 2 sitting judges. One judge is the in-charge judge of the Technology Construction Court is from Kitting Chambers, which is known for their construction and infrastructure work. Ratan sir is from Kitting Chambers. And if you look at how it has functioned in last 150 years, so you name all important judgments that we refer in construction and infrastructure disputes world over, starting with Water Lily, MT, Hotgard, multiplex construction, Triple Point, PIC, all these judgments are delivered by Technology and Construction Court. Let me complete. So, taking a cue from this particular jurisdiction, then today we have construction courts, statutory adjudication in all major jurisdictions. Let's say Australia, Victoria High Court, New South Wales High Court, they have this technology construction list, not court per se, but judges will only handle those particular disputes. And if you look at the makeup of that particular court, judges there also have domain knowledge. For example, Honorable Justice Steen, if you look at her history of work, she has published papers on how construction arbitration or construction dispute should be resolved. And she has opinion on how the expert opinion to be dealt with. So she is talking about the first conclave of the party, both sides experts. and that conclave will happen in absence of parties. They will be asked to give their opinion on their agreement and disagreement. What documents do they require? Having done that, the second conclave will be in presence of parties. And there again they will give their second report. So basically, these judges, benches, they have bandwidth to handle heavyweight construction infrastructure disputes. Similarly, Hong Kong has not only statutory adjudication, but they have the High Court there has this HK list, arbitration list, which will handle only construction and construction and infrastructure matters. Similarly, New Zealand has it. In Canada, Ontario state has Ontario dispute adjudication for construction contract. And the experience has been quite good. When we talk to international construction law practitioners, from their opinion, the practice has been quite good. The arbitration has almost reduced for construction and infrastructure sector in those jurisdictions. And in India, it's high time. We require not only statutory adjudication, we have a dispute adjudication board clause in our contract. But the problem is that of enforcement of those decision of dispute board. So therefore, we need statutory adjudication and specialized construction courts, let's say on the lines of now how Delhi High Court has IP bench and Madras High Court has IP bench. It will go a long way. There will be subject matter experts handling those disputes, and moreover, all the techno-legal professionals who are in this room will be getting to participate in resolving those disputes, unlike how it is happening today. Let's say if there is a dispute in Delhi High Court, you will have to go to Ratan sir. Now, counsel like us, for 10, 15 years we have spent in court, and then we ended up specializing in arbitration. So the techno-legal consultants will not have to take that route, and maybe straight away get to participate, provided you have domain expertise and experience. Therefore, we are for the motion. We require construction court and statutory adjudication.
Thank you. Thank you, Ronak, for all your thoughts. Because you shared interesting statistics and how it works in the real life. Mr. Pradeep Reddy, you have a tough task. If you see the screen and if you see how people see this motion, you have to really work hard, as Venkat said. So we will start with you.
Sure, sir. Thank you. First, let me share a very quick joke. A father sees his son going by, calls him and says, "What is 6 times 6? Son says 37 instead of 36. So the father still praises the son, gives me chocolate. Now his father's friend is sitting next to him and says, "Rabbi, 6 times 6 is 36. You said your son answered 37, yet you still gave me chocolate." Well, the father says, "Earlier he was in 40s, he's made progress and he's come down to 30s. Please remember this number 37, because incidentally, that's what I'm going to rely upon later." Now my friend talked about international experiences. Those are all international experiences. Those are not national experiences. We are talking about changes in India, and we are seeing somebody else's experience. Paradharmam bhayanakam, if I have to quote the Bhagavad Gita. I'm invoking God, sir. I need more strength. But let us also look at what internationally happened. Many companies came to India, like McDonald's, Burger King, Pizza Hut, or Starbucks, Dunkin' Donuts, all these people. But they Indianized. They did not adopt the American model. They completely changed their working time. Instead of starting at 7 o'clock in the morning, they start at 11 o'clock. Instead of just having 3 or 4 items, they are providing Indian Mek Maharaja, or Indianized spices and breakfast items, which you don't find in the US. So just copy-pasting that here is not going to work. Let's also look at Singapore, the rank number 1 in 2021, along with London. If you see, Singapore was one of the initial countries that signed the New York Convention. It was in 1986 that Singapore signed. And SIAC was established in 1991. But by 2004, people slowly started leaving Singapore because they had made some changes that did not allow arbitration to be that friendly. Realizing their mistake, Singapore corrected itself in 2004. They made significant amendments that allowed foreign lawyers to come in, third-party funding, minimal court interference, and all those things. And today, Singapore is one of the most sought-out countries. We, on the other hand, have a different situation. In India, for everything, we invoke public policy exception. What exactly is public policy? It's an unruly horse. We don't know where it's going to take us. That is a classic definition. And then we have what? 34, 37, SLP, review petition, curative petition. So court is interviewing in every step of the process, not just arbitration. We have 5 crore plus cases pending. And as the Honorable Justice was talking in the morning, the courts have cleared about 15 crore cases in the last 10 years. So what we need to do is strengthen our existing courts, reduce the court intervention in what is going on. People say that, let's have another construction court. Okay, where do I need to file my application? In the construction court, or the civil court, or the commercial court, or the MSME? Because those are the disputes, even though there's no there's no construction court, we end up to court trying to identify the jurisdiction. That's another 3 years gone. Once the jurisdiction, then the court says, transfer the file to that court. Then we go to that court, they say, now the pecuniary limit, you have to go to that court versus this court. That's another 3 years gone. I still have a section 11 pending for the past 5 years in the court, just for appointment of arbitrator. Similarly, my section 34, or in fact, one arbitration has been going on for 8 years. My 34, I've been sitting on it for the last 6 years, hopefully trying to get it to the execution stage. Okay, let's assume for a second that we go for construction courts. What about execution courts? Are you now going to insist on another execution court? Is that what it is? We need more courts and more courts? My photo did not come up. Divya? Yes. So it doesn't matter how many resources you have if you don't know how to use them. So learn to use what we have. We are talking about more courts, right? Let's look at what India did. Over the last 60, 70 years, we have developed literally 37 forums, specialized forums, like DRT, DRAT, family courts, consumer commissions, MSC, FC, the RERA, Electricity Board, Telecom, Railways, NCLT, IT Appellate, multiple forums, 37. So we made progress, right? Now instead of going closer, my friend is asking for go make it 38 forums. And do you know the functionality of these, or the success rate of these specialized forums? 20 years ago, we started with the MSc, FC, MSME Act. 10 years ago, we got the NCLT, IBC. 10 years ago, we got the commercial courts. But the number of cases pending, just to give quick statistics, NCLT, more than 30,000 cases are pending as of now. Supposed to take 270 days with the extended time, but we end up with more than 700 days. Plus court intervention. IT and other tax-related appellates, more than 1 lakh cases. DRT and DRAT, more than 2.5 lakh cases. Family court, 15 lakh cases. Consumer Commission, 6 lakhs cases. All other forums put together, another 10 lakhs cases or more. That's the pendency in the specialized forums. So what exactly are we trying to do? Speedy resolution doesn't come from that. If that is the case, for every gunshot, we need a separate court, a judge who is experienced with firing a gun, or for fingerprints, or for DNA. That is not the answer. The answer is filling up the vacancies. We don't need any new statutes. Our the Contract Act, the Contract Act is 150 years old, underwent only 2 amendments. For a 10 rupee dispute to a 10,000 crore dispute, we still rely upon the same Contract Act, and it works fine. We never envisaged electronic messages or anything. Still, the Contract Act is still applicable to that. So everything is there. We are just not able to open our eyes and see what's there. So I say, sir, that we don't need anything new. Just get us a few more judges and fill in the vacancies, and we are good to go. So I say that we don't need more, just use your existing resources better. Thank you.
Thank you. Yes. So Mr. Pradeep Reddy says, be happy with what you have. Don't peep into others' jurisdiction through these holes, and be happy with this. Now let us see how this mentometer moves.
Are you still for the motion or against the motion or still undecided?
If you have to vote for us, it is against the motion.
No. They are knowledgeable enough to know
No
that.
canvassing. No,
No,
none of them are supposed to canvass for the vote. It is just
They will be
strictly
disqualified.
voted. They will be disqualified. That I'll remove that.
Who are in the room? Quickly. TVK? No, they will reverse it in the second round. No, I'm just saying. They're always wrong. Now the undecided has become from 2 to 6. Yeah. Quickly, please. Sridharji, you are the scorer, so you will be. No, you just take a picture once it's done, once it's close to. I think we know the trend now. I think we can take.
Any change, Pradeep?
Sir, you can see here.
पहले क्या था भाई? अब घट गया.
Now against motion ka hai.
It just changed.
सर एक पार्टी पोल मैनेजर है, कोई पार्टी पोल मैनेजर है.
Okay. Yeah, fine. I think it's fine. The gap is. We know the trend now. Okay, now we'll go to the second round, sir. The final round, then we will come back.
So we have Mr. Ashwini Malhotra, very fine, very hardworking construction lawyer, and his acumen is really worth praising. Ashwini, your task is tougher now because there is major shift in the poll. So, yeah, your thoughts.
Thank you, sir. So we are dealing with two things here. One is the mechanism which requires an institution, which is a statutory mechanism of adjudication. The second one is specialized courts. Sir has not said anything as far as the adjudication mechanism is concerned. Sir, Ratan sir has already explained it in detail. I will just take a minute. What lies at the heart of construction industry is liquidity and cash flow. A contractor who does not have sufficient cash flow will not deploy sufficient manpower and machinery at the site, and he won't be able to meet his deadline. And if he won't be able to meet his deadline, he will be placed with a penalty or liability called delay damages, which is there in every construction contract. What interim adjudication mechanism does is this. For instance, if the contractor feels it has carried out a work of 10 crore rupees and the employer disagrees with it, it feels that only 5 crore worth of work has been carried out, it allows the contractor to approach in the interim while the contract is subsisting the adjudication board and get his disputes adjudicated without halting the progress. He does not have to go for an arbitration and wait for 3 or 4 years. He can go to the adjudicatory board as people do in UK. They will pronounce a decision within 28 days and the construction can go on. So this mechanism by itself provides a concessionaire who has to invest his money with a great support, and when our economy is booming and we are harping upon how construction disputes are increasing, I think it's also a time we bring into place a mechanism by which the construction process, the smoothness of a construction process can be ensured. This is as far as the mechanism and the adjudicatory process is concerned. I thought I will also harp on from the practitioner point of view. I practice mainly in Delhi High Court. The unique thing about Delhi High Court is this: it's a city court, it's a city state. So Delhi High Court is not burdened with as many matters as, for instance, Allahabad High Court is. And basically, when it comes to a commercial division of a high court, it works in this manner. You have a supplementary list which covers the fresh matters, and then you have the old matters list. For the most part, each and every court is burdened with at least 80 cases in a day. Now imagine taking a construction dispute, which is voluminous in nature, which is technical in nature, before those courts and expecting them to deliver justice. The fact is, we have seen this in the arbitration as well. It takes days for the judge to fathom the subject. We emphasize on, when it comes to arbitration, that a person who has expertise in that field should be appointed as an arbitrator. But when it comes to court, we expect a person who is dealing with banking and finance matters, who is dealing with DRT matters, who is dealing with debt matters, who is dealing with mines and minerals matter, to also decide construction disputes in that same day within a period of half an hour to an hour. So when we expect the arbitrators to have expertise, we cannot basically say that the courts are capable, do have the infrastructure. They may be capable, but they have an infrastructure to decide the disputes related to construction. The fact is this: I was researching the other day Indian judgment on critical path theory. I was working with Sir on that matter. I found out that the critical path theory came into being in 1950s or 1960s. And I was trying to find an Indian judgment on it. The only one case which I could find was pronounced in 2026. That too in a 34 jurisdiction. That too by a judge who was elevated to the court because he used to practice construction law. The point I'm trying to make is this is a highly technical and highly voluminous field. You cannot expect a judge to deal with these disputes within an infrastructure where he is already burdened with other matters. Sir was saying that we should not mention about the experience of other countries like UK, Australia, and we should talk about our own experience. But the fact is this: even when it comes to arbitration today, you cannot do a construction disputes without relying upon foreign case laws. And someone was also saying Rome is not built in a day, but someday you would have to build the Rome. You would have to develop your own jurisprudence because you deal with peculiar facts dealing with your own country. You have different contracts when it comes to DDA. You have different contracts when it comes to PWD. You have different contracts when it comes to NHI. It has been 80 years and we don't have any construction jurisprudence per se in this country. So for that purpose, it is essential, even if arbitration is there, you don't stop developing railway because you have roads. Even if arbitration is there, you need to develop your own jurisprudence. You need to develop your own precedents, and that's how you grow as an industry. I think I will rest my case on this.
The judgment which you referred to, Aswini, I understand you are referring to FCON. In that judgment, again, judge before whom this matter went in 34 did not discuss the critical path, application of critical path or methodology. He simply accepted what arbitrators had done, because before the arbitrator, the contractor side had talked about the concept of critical delay, and so on and so forth. But this is what it is today. Now we have got the most charming speaker.
And the toughest job after everyone seems convinced already.
So let us see how it goes.
What is it? It's the dabbling of bar? That was the
Is it?
passing out. Sir knows what I'm talking about.
Oh my God, I haven't heard that.
Not about you, it's about somebody else.
Okay. Okay, so I think our opponents have definitely painted a compelling picture. Stalled projects, stuck cash flow, and none of it is wrong. But what is actually wrong is the cure that they're trying to propose. Let's just try to reframe what this debate is talking about today. What it's saying is that we need statutory adjudication to be able to succeed. Now, that's not a modest proposal. What you're really implying is that I, today, as a country, am literally useless, and I cannot move beyond unless this is taken care of. And how do they want us to take care of it? They want us to copy a mechanism from a different legal ecosystem developed in a different context. Now, it's not that I disagree with the particular idea of it. I do not disagree with the idea of it. All I'm saying is, not now. And that now is what needs to be resolved at this stage. What they're trying to offer is not a solution to the problem. They're actually issuing a certificate of surrender, and they're asking us to countersign it. I'm not willing to do that, and it has some reasons. One, the problem is upstream. It is before the fight even begins. It is not the forum. When you're talking about delayed payments, yes, it does stall projects. But where does the dispute really begin? Construction disputes are not about legislative failures, they are about management failures. You cannot legislate your way out of a dispute that was created by a pen or by a shovel. It cannot be done. You don't need a gavel. You need project execution with the right kind of contract governance and the right kind of administration behind it. Next, argument 2. Remember how many I'm going to make. Okay, the international experience. Yes, Dr. Reddy has also spoken about it. I think those are fantastic legislations. I admire what they've done, the jurisprudence that they've created. Yes. But again, what did they do? They had a functional legal ecosystem and dispute resolution system before they built on top of it. The incremental layer came when their foundation was solid. Today, what they're asking us to do is to build an added floor when the foundation is still shifting. How is it that I build that first floor if the concrete is still pouring and the cement is not set? How do you do that? We cannot redesign the waiting room when we haven't done with the queue yet. We haven't fixed the problem of the queue yet. And why do you think that happens? That happens because the enforcement culture is not there. It's because parties inflate their claims. They want to defer payments by filing one petition after another. That mindset needs to be changed before you get another forum in the mix. like the 38th forum that Dr. Reddy was talking about. You need to resolve those issues first. Now let's take the context of India. This is 4 days ago. I'm not talking of a decade ago. I'm not talking of 5 days, 5 years ago, 2 months ago. I'm talking 4 days ago. There was a case called MP Road Development Corporation versus Jabalpur Corridor. And I quote what the judge said. Arbitration in India has not failed. Courts sometimes have failed arbitration in India. Judicial interference in alternate dispute resolution has often been a cure without a disease. This was a case which was awarded in 2014, and today in 2026, the Supreme Court said that the contractor has not seen any money. How can you even fathom building another specialized institution on top of this? The next argument. Now, the next argument is argument number three. Arbitration is not the problem, it is the patient that we've abandoned. So we have failed the system has not failed us. Commercial parties are not just looking at outcomes, they are watching for predictability. And today, our ecosystem cannot guarantee the predictability that the commercial parties are looking for. Again, the same thing, right? Pressure tactics and multiple other things that we are seeing. When my opponents are talking about DABs, yes, they're a great tool. You get it decided within 28 days, and I'm in front of a government party who's going to complete the process and then not adhere to that DAB decision. So what do? I go to court to get it enforced? Wow, that's quite the solution, isn't it? So I think the moot point here is really just that we need to understand the root cause first. Even the government is retracting from this process. Now that notification that the government issued and the various government entities are now fortifying is not an advertisement for another forum. It is a crisis call. You fix the system first. They're moving towards mediation. Why are they moving towards mediation? Because these projects are capital intensive, they have long gestation periods, and you need to resolve them with a commercial mindset. What I am telling you is, go one step further back. Fix it before it starts. You don't even need to go to mediation or any other dispute resolution forum, then leave aside getting another one or building another one altogether. And the last one. Again, Mr. Desai spoke about multiple lists in multiple jurisdictions of experts that are there. Do we have the human infrastructure for it? We don't. We absolutely don't. As of today, the construction industry has only 4.4 million core skilled workers. When I say core skilled workers, I'm talking about engineers and technicians. You're running $1 trillion industry on the back of 4.4 million core skilled professionals only. And you want to staff another system altogether. If you cannot staff a system that you already have, how do you go any further beyond that? We need judges we need about 50 judges per million in our population today. And this was something the Law Commission said some 37 years ago, if not more. We're still at 21. The jurisdictions that Mr. Desai is referring to have anywhere between 50 to 150 to 240 judges per million population. How are you going to fill that gap with another specialist court if you don't get into the root cause of it altogether? So yes, please vote against the motion. Let's build the first floor first before we debate the penthouse. Thank you.
Thank you, Mahak. Lot of claps. Not a good sign for you guys. So Mahak says, put your house in order, all will fall in line. This is what Mahak said. So now it is time to see. We have heard both sides. Now, I think let us have vote first, because otherwise I may influence something. Oh, there's one more round remaining. Oh, so one minute per speaker. Okay, speaker. So Ronak Desai.
So first of all, I think they have completely misunderstood what the international perspectives that I was talking about was not to draw parallels. I was talking about the best practices and how it worked in various other jurisdictions. I wear tricolor on my sleeve. I doubt their nationalism when they doubt the native intelligence of construction industry. So this is not nationalism, this is jingoism. Second thing, I think they have completely misunderstood the concept of statutory adjudication. The very basis foundation of statutory adjudication is we don't have to go to court. And once the dispute is settled by statutory adjudication, you have to go to court, you have to deposit the entire amount of that particular decision. And that's why the arbitration has died in those jurisdictions where the statutory adjudication was implemented. The next thing is the judgment cited by Mahek squarely favors our case. It says that arbitration has not died down, but construction dispute resolution mechanism has died down. 2014 the award was passed. The contractor is yet to see the color of the money, so I'm grateful to you cited that judgment. Even after that judgment, if we are ready to say that everything is hunky-dory, nothing is required to be changed, that's not the case. Dr. Reddy talked about various implementation measures that can be devised in to solve the present system. And he drew parallel with Singaporean systems. When he cites, the best practices from Singapore, that's all okay. We cannot cite that. We have all those measures have been implemented, done and dusted, and then Supreme Court has arrived at this decision 4 days ago. And I think the last thing that Dr. Reddy quoted from Gita. I'll quote from Gita, what Oppenheimer said, Kalasmi, I am the destroyer of the death. So the current dispute resolution mechanism system in India is dead, and Krishna is coming on the way.
So I will be very brief. What is the state which exists at present? Government does not want to go for arbitration. When it comes to Indian courts, and I was asking this to myself, but I'm asking all of you as well, and the opposite side as well, can you name at least even 3 cases which have been passed in a large-scale construction dispute by an Indian court in its original jurisdiction in past 80 years? Any 3 cases which have been. And the fact is, you have also harped upon the documentation and mediation. I feel this is confusing the issue. There is an issue as far as documentation is concerned. The parties don't have adequate documentation, which makes it humongously difficult for an arbitrator to arrive at a factual conclusion. But the problem is not this. It is about state building an institution to resolve construction dispute. As a state, you cannot say to the parties that you put your house in order, we are not going to do anything. So that's my limited point.
Yes, Mahak.
Okay, All well said. First of all, yes, if you want to call me an anti-nationalist as far as the native intelligence is concerned, I'm questioning it. As far as construction law is concerned, I think everyone has said that we do not have construction jurisprudence in our country. Why do we not have it? Because there are lack of experts in our country. So we need to build on that first before we build that court. Yes, it took 12 years for the judgment to pass, but the solution is not. It is absolutely not to create a specialist court right now. I'm not saying it's not the solution. I'm saying it's not the solution right now. Build your capability, train the people, accredit construction arbitrators and construction lawyers. That's what you need. I don't want the dispute to go to that point of a dispute. I'm asking you to resolve it at the stage where it is best contained, and so that you do not end up raising a claim of 10,000 crores. Governance is what is important, and the sequencing matters. I'm only asking for the right sequencing. Fix your foundation first. Don't jump into another legislation because it's just going to join the list. It's going to be a well-intentioned legislation, yes, but it's going to have another unmet promise because you do not have your house in order. So you need to face reality, not be in denial, stop copying other mechanisms, at least till the time you're ready for it. Nakal ke liye bhi akal chahiye. Thank you.
Final argument, right? This, nothing after this.
Nothing after this.
See, my friend challenged me to name 3 cases in the last 75 years or so, 80 years. I'll not ask for 3, I'll ask for 1 out of the 37 forums. So show me 1 forum that was successful. You cannot answer back. You're done. Okay, and there is no such forum. You can verify for yourself. Don't just believe what I say. Verify for yourself, and then realize that none of the 37 forums have been successful for India. And Krishna did not say, let's fight. He said, you do your job first, then I'll help you. Krishna is already here. We're just not fighting. We have just thrown out Dhanush, and we are saying, we want a 38th forum. And patriotism. I'm not wearing khadi, but I'm wearing made in India. Khadi is not just nationalism. Made in India is nationalism. So you cannot answer back. And people are talking about jurisprudence. They're not saying that the current law is bad. They just want a Supreme Court to clarify some things. That's it. We just need the jurisprudence to come out. And just incidentally, I have a practical example. In the last 10 years ago, the state of Telangana and Andhra Pradesh was split. And the courts were split. Separate High Court in Telangana, separate High Court in Andhra Pradesh. Number of cases doubled. So, just by splitting the state, cases did not decrease. People saw, people today, even today, there is 5 crore cases pending. We still believe in our judiciary. It is the last standing symbol of democracy in our country. Why do you want to forget that? Why do you want to choose something else that doesn't exist? One final thing which I will conclude. A person is unhappy with his family, he wants a divorce. So he abandons his family, comes and joins a Swami. Swami hears this case and says, that's okay, stay in my ashram. 3-4 days later, this person sees the Swami searching under outside the corridor. The person asks the Swami, what is happening? So the Swami says, I lost my ring, so I'm trying to find it. So I think sir knows the story. So person says, sir, Swamiji, where did you lose your ring? He said, I lost it below that tree. Then this person says, why are you searching here? Well, it's too dark over there to find anything, so I'm searching here. So the person answers, well, you need to look for the ring where you lost it. So Swami says, that is exactly what I'm saying. Your happiness or unhappiness is with your family. Go back there and find your happiness. We are happy with the number of forums. We are unhappy with the number of forums. But let's not try to abandon that tree because it appears to be dark. Let's show some light there. I'm Pradeep, a source of light. Thank you.
So, ladies and gentlemen, it was hotly debated topic, motion. And both sides played all the cards, including emotional card and card of being pure nationalist. So now ball is in your court. Let us see which way it goes.
Later.
No, then it will influence. It will influence the vote. I don't want to. Yeah.
closing statement I was saying. There was in the format it was there.
After the vote.
So, after listening to both the sides, including the rebuttals, please vote now. We have 140, we will wait for the 140 to be voted. It's like a BP monitor. Please don't try to match it, eh? Yeah. We have the trends now. Mission may be fault. What's happening?
EVM tampering.
So what I'm watching is at least there is 150 phones in the room.
See, what happens is, the party which senses that I may have difficult situation, before result comes, he starts saying that something wrong with you know, you are doing exactly this. Wait, no, have patience. You say that we will win in the last breath.
We win, sir.
Yes. Like, most of the politicians on TV, they know that they are losing.
I'm not a
Yes,
politician,
they
sir.
will say,
I'm not a politician, I'm a realist.
say I win.
I'm winning.
Yes.
What happened? Yeah, why it's like this? I don't know why. Why it is?
ट्रेंड तो जो आपको दिख रहा है वही लग रहा है पर मैं ये सोच रही हूँ कि 150 लोग मुझे दिख नहीं रहे कमरे में वोट का
When there is serious doubt about the authenticity of the whole process,
Yes.
she says we're from 150 people.
Yeah, these are not 150 people.
Number of voters is not matching the population.
Yes. If you take a count, these are not 150 people. Where is the vote? Yes, indeed.
But you need to go to court.
It is being rigged, right?
ये कहाँ चला गया? Why are they not showing it to us now?
See, even computer agrees with us.
EVM hacking?
See, I'm not objecting what I cannot prove. I'm just seeing.
Do you want me to get the head count?
I don't mind.
No, no, as a judge, if there is serious doubt about it, then there be head count. Yes, presence, like class is
Ado.
No, I've taken as
Yes,
evidence.
yes. Mr. Moderator, I want a head count. I want a head count.
Professor Venkat, Mahek says she has serious doubt about the number of votes in comparison to the presence in the audience. She says, I want head count.
Head
She
count?
says he can't be her quality.
Okay, we can have head count.
Earlier it was 140.
It's 151, where is 150?
151 phones.
Huh?
Somebody may be having 2 phones.
That's wrong, then that they cannot do.
That is your
Yes.
People have 2 phones. What to do? Okay.
So that is more than 75.
Yes.
Okay, 74.
Who is one undecided person?
Can the Mahek has a very interesting question. She says, who is that undecided person? Can he or she raise his or her hand? Oh, he's there. Yeah, he continues to remain undecided.
So what will make you convincing?
he is CPA CPM.
Probably when he comes here, you will get convinced.
Yes, you can come here and say what you want to say. Come. He
That's the only solution.
Okay, I think the clear winners, 56 is bigger than any other number. Let us strongly agree. So the motion is passed.
Now, so since we have seen the results, see, the answer lies in this. What team A said and what team B said. What Mahek says was very interesting. Mahek says, create a good pool of construction professionals who can represent the parties efficiently, who can decide the construction disputes efficiently as the judge or the arbitrator. So create a better pool. How we do it? The way we do it, like, having programs, courses, certificate programs and all of that. What this other side says is, let us have a statutory adjudication regime by way of a law enactment and have a specialized court. Mix of both is going to solve the problem. We can't simply have like what we did. We wanted to have commercial courts. We have commercial courts, no? Who are manning those commercial courts? Who are presiding those commercial? Same set of judges in circulation are doing this. It doesn't help. How you will be helped is bringing those required changes by way of legislations and courts, create a pool of good construction lawyers and construction arbitrators and construction judges, make them sit there as judges and the arbitrators, then you will have a complete solution to it. Those changes in those jurisdictions have made fantastic changes. See, one example, and I'll close this session. Anybody who has gone to Supreme Court would see one judge deciding SLPs in 1 minute. Oh, understood, dismissed, allowed, dismissed. How? Because all through their life they have done criminal matters, service matters, civil matters, property matters. The moment they read the brief, they understand this is the dispute, this is the position, he is right, he is wrong. But when it comes to specialized subjects, which is complex and technical, unless you have judges who can understand those disputes, he'll never be able to decide the disputes. Same is the case with the arbitrator, because most of the arbitrators are retired judges. We need to create situation where all stakeholders, all professionals are aware of construction law jurisprudence, which is eventually going to help us. So, ladies and gentlemen, it was very lively debate, hotly contested, no stones unturned, and they have gone to the extent of evoking your nationalism, and they have gone to the extent of making religious slogan, which I quietly listen to without saying that certain, you cannot go beyond point in a poll, elections, right? It was like asking everybody to poll. But thank you very much for being such a supportive and enthusiastic audience, and rather not audience. You were all participating in this process. And thank you, Professor Venkat, for this interesting thing which you do every year. Thank you very much, ladies and gentlemen. No, everything is justified in love and war. All done. So Tim on my right hand side wins, ladies and gentlemen, and other side also wins. Let us be hopeful that we will have a better ecosystem for construction professionals in this country. Thank you very much.
That was a magnificent display of sharp arguments and rebuttal strategies from both the sides. I now request Professor Venkat to felicitate our panelists and moderator. Our moderator, Professor Ratan Singh, sir. Our first debater, Advocate Ronak Desai. Our second debater, Mr. Ashwani Malhotra. Our third debater, Dr. Pradeep Reddy, sir. Our fourth debater, Advocate MAHE Oberoi.
Before we break for lunch, there are a couple of announcements. Just before this conference, we had another important event with the India International Arbitration Center. Manipal Law School has conducted a 5-day arbitration workshop, which included 3 days of online sessions with various international speakers and Indian arbitrators and counsel. And last 2 days, yesterday and day before yesterday, we had a mock workshop, including cross-examination of witness, pleadings by the counsel. Then after that, I think the tribunal, arbitration tribunal, wrote an award in a record time. In 1 day night, they could pronounce an award, of course, without the quantum, at least on the merits of the case. So then we had a very interesting discussions yesterday with Ronak Desai and Mr. Naveen, the CEO of India International Arbitration Center. So we take great pride in providing the certificates for the successful completion of the program. So I will call out Mr. Naveen, the CEO of India International Arbitration Center, to come to the stage to hand over the certificates to the participants.
Mr. Deepak M.
Deepak acted actually two roles. Actually, he was an expert witness. Also, he was actually a quasi-counsel. I think he was excelling as a counsel rather than expert, I felt.
At least something is decided now.
Mr. Sunil Kulkarni.
Sunil has acted as an arbitration tribunal, and he bombarded the claimant and responded with a lot of technical questions, being a very experienced general manager from one of the leading companies.
Divya S. Kumar.
Divya? Oh, you have to come from long? The camera is not panning. Yeah. Divya is actually an LLM student. She's having an electronics background, all kind of MBA and all kind of working. So she's finally joined a construction law. And she has been a very fierce counsel, I would put it that way. So I'm glad that she enjoyed the journey, and she's also part of this conference, one of the pillars.
Thank you.
Nidhi Thakur.
Nidhi is actually technical, moving to a techno-legal now. She has been a student of the PG diploma program, acted as an expert, very, very composed, and she was done a good job as an expert witness. Who else is pending?
Manjula K.S.
Advocate Manjula is actually a practicing advocate, and he is a mediator, and she has a lot of hats to wear. And she has been one of the outstanding counsel, right, as a claimant.
Mr. Saran Raj.
Saran Raj is actually a counsel for respondent. He has done an extremely good job. He looks very composed, but the way he argues, he actually very sharp actually. That's all? Binu is not there? Okay. We'll have a group picture. Come. Two of them are not there. For tomorrow is ready.
A kind announcement. I request all the delegates to move to the executive lounge, which is in the ground floor of the MAHE building, for your lunch. And the students are requested to move to the ground floor of MAHE building. We have the student coordinators who will show you the way, and the lunch break is for exactly 1 hour.